This is Bloomberg Law with June Grasso from Bloomberg Radio.
The NBA will have to face a class action video privacy lawsuit, which accuses it of sharing personal data from viewers of videos on its website. The plaintiff, Michael Salazar, signed up for the NBA's online email newsletter and alleges that when he watched videos on NBA.com, the league shared his video watching history with Meta without his permission. A federal judge dismissed his lawsuit, but the Second Circuit Court of Appeals has reinstated it. Joining me is Ira Steinberg, a partner at Greenberg Glusker. Tell us about the case.
Sure. The plaintiff in this case alleges that he signed up for a newsletter from the NBA, and that as part of signing up for this newsletter, he gave the NBA certain information, and that the NBA's website has video content on it. And their newsletter has video content in it, and that by signing up for this newsletter and watching the video content, some of the information about the videos he watched were transmitted to third parties, and that was a violation of a law called the Video Privacy Protection Act, the VPPA. And the VPPA was passed in 1988 after Robert Bork's video rental history was published in a newspaper article, and Senator Patrick Leahy, the Democrat from Vermont, became offended by this, among others, and they passed this law, which makes it illegal to share personal identifying information regarding the video rentals of a renter, purchaser, or subscriber of goods or services from a company. And so the NBA case is really about whether the plaintiff who had signed up for a newsletter was a subscriber under the VPPA, and whether the newsletter was goods or services that would trigger the VPPA.
And what does the NBA say?
The NBA's argument is that when he signed up for the newsletter, when Salazar signed up for the newsletter, he didn't sign up for audiovisual content. He didn't pay for audiovisual content. He signed up to receive a written newsletter with news and updates about the NBA. And that letter, his sign up for the newsletter had nothing to do with the audiovisual content he received. That whatever he was a subscriber to, if he was a subscriber at all, it wasn't to audiovisual content.
As you mentioned, the VPPA was enacted in 1988 before there were these kinds of websites or, tracking people online. The Second Circuit said it's no dinosaur statute, but is it a dinosaur statute? It doesn't seem to match what's happening nowadays.
This is actually fairly common in a lot of these disputes that are coming up in multiple states. I practice in California. That's what I know best. And in California, like many other places, there is no data privacy law that you can sue a company under directly. Like, for example, in California, we have the California Consumer Privacy Act, the CCPA, and it lets a consumer sue if there's a hack. But if you just think that, you're on a website and it's sharing your data, you can't ordinarily sue that business. And so consumers are looking for different laws to borrow from to sue under. And those laws are often older pre-internet laws. So there's a lot of lawsuits under old wiretapping laws and under the VPPA. And so it's actually pretty common. It happens in a lot of areas where courts are trying to wrestle through how do you apply a pre-internet law that wasn't built for the internet to a data privacy claim. Courts so far have been very open to the idea that just because a law is pre-internet doesn't mean it can't include data privacy claims. But then you have a lot of cases like the Salazar case where there's a little bit of a square peg in a round hole problem, where it's hard to figure out how a law that was written, in a very different context would apply to the internet. I mean, the VPPA applies to videotape service providers, right? The NBA is obviously not literally a videotape service provider anymore, if it ever was. But many courts have held that it's actually broader. It can apply to all sorts of businesses that provide audiovisual content, even if it's not literally a videotape. And so that's a good example of how the courts are really wrestling through how do you apply these pre-internet statutes to modern data privacy claims.
The NBA told the appeals court that all kinds of businesses, from news outlets to cereal companies, have been hit with baseless video privacy class actions by consumers who merely viewed free videos on company websites. Has there been a flood of these video privacy class actions?
Absolutely. The NBA is right about that part. I guess baseless is a matter of opinion. But the NBA is correct that there has been a huge increase in data privacy litigation under the VPPA and also, as I mentioned before, under wiretapping laws and similar pre-internet laws in a variety of states. They're absolutely right about that.
I understand that in the past year there have been a lot of dismissals of these cases. Does the Second Circuit decision stand in contrast to other courts?
Yeah, absolutely. So in California, in the Ninth Circuit, which is the federal appeals jurisdiction for most of the West Coast and the Western U.S., the courts have been a little bit more skeptical than the Second Circuit has about certain aspects of the Salazar decision, in particular, the goods and services issue and the subscriber issue. So in the Ninth Circuit, there's more cases holding that the goods and services component of the VPPA applies only to audiovisual goods and services, right? So the NBA in their arguments in the Salazar case talk about how if you had gone to a hardware store and bought a hammer and then watched a video, you would in theory be subject to the VPPA because you bought a good and then you watched a video and that was subject to the law. And in California, that kind of a case would probably be less successful than it would be in New York in the Second Circuit under the Salazar decision. And then again, as the Salazar decision points out, there's several different jurisdictions all trying to understand what a subscriber is under the VPPA. And they agree on some baseline points, like, for example, you don't necessarily have to pay to be a subscriber, but you have to give something of value. And where you draw that line of what counts as a subscriber, what's valuable enough to make you a subscriber as opposed to someone who just watched video for free, we're starting to see variation among the judicial districts. It reminds me a lot of the Americans with Disabilities Act litigation for websites, where there was a big wave of that. It's receding a little bit, but there's still a fair amount of it, where New York and the Second Circuit were initially very open to those claims. They said that, an internet-based business with no physical location is absolutely subject to Title III of the ADA, and that opened up a flood of ADA litigation against websites. And the Ninth Circuit, the Western U.S., was a little more skeptical of those claims and tended to require a nexus between the website and a physical place of public location and did not open ADA claims to purely internet businesses. And so I'm seeing a little bit of a parallel where the Second Circuit is opening the doors more widely to consumer cases than in other judicial jurisdictions, including the Ninth Circuit.
Tell me what exactly you think this decision stands for.
I think it stands for, at least in the Second Circuit, it's going to be fairly easy for a consumer to come under the VPPA. And the litigated issue in a lot of these cases is going to shift from whether the consumer is even subject to the law to whether the website is improperly sharing personal identifying information. Now, as a practical matter, what that means is it's going to be a lot harder for a business to get these cases dismissed very early on. In the Salazar case, the NBA filed a motion to dismiss, which is a very early motion to get rid of a case. And the Second Circuit essentially said that motion should have been denied. And I think now it's going to be a lot harder to get rid of these cases early on because they're going to really be focused much more on the merits of the data practices of the alleged videotape service provider.
What can companies do? I mean, there's possibility, right, of getting consent?
Yeah, so compliance with the VPPA is a little bit tricky. And that's because the consent provisions in the statute require that consent be given in a standalone agreement. So you can't fold your privacy disclosure and consent into your larger terms of service or privacy policy like you would in other cases. For example, when we'll put on a consent defense to a wiretapping case in California, oftentimes the website will have a privacy policy in terms of service, and we could rely on the disclosures and the consents in those larger documents. You can't do that for the VPPA. So the consent process is a little bit more tricky under that law. The first layer of defense with these types of consumer claims, to me, is always your dispute resolution policy, because it's going to be harder and harder to stop people from filing these claims and getting them dismissed early on. So you want to make sure that essentially the forum that you're litigating in, the architecture of the dispute is set up so that it's manageable and it's fair from the perspective of both parties and that it's enforceable. We've seen a lot of companies fall into what's called the arbitration trap in other consumer data privacy claims where they have an arbitration provision and they have a class action waiver. And so instead of filing a class action, you'll see 10,000 or a few thousand or a few hundred arbitration claimants all come together and then file these mass claims. And since arbitration fees or the filing fees are usually assessed on the business on a per claimant basis, it can massively increase the cost of defense. And that's been very problematic for some large companies defending these data privacy claims. So it's really important to get your dispute resolution policy really squared away, top-notch, organized, and well thought through. Beyond that, you're right. If your company is at high risk of a VPPA claim because you are very much in the business of audiovisual content and you're sharing data and all those kinds of things, you might want to consider whether you can incorporate into your website or your newsletter or whatever you're doing some kind of standalone consent that would comply with the VPPA. Otherwise, if you can't get that consent in, you just need to think about what data you're sharing and whether or not you can adjust the process or the way you engage with your consumers to make sure that they are not technically subscribers of the VPPA. Unfortunately, there's not a very easy answer for the VPPA, at least under the Second Circuit decision. The law is still developing, so there's not a lot of bright lines where we could say, if you do this, you'll be safe. There's only things we could do to turn the dials to reduce risk where we can.
And do you think that this decision will lead to more lawsuits under the VPPA?
Oh, I know it will. Absolutely.
I don't usually get such definitive answers. So what are the damages here if the NBA loses?
It's $2,500 per person. It's technically actual damages, but not less than $2,500. And in reality, most plaintiffs aren't going to have actual damages, so effectively it's $2,500 per person. But one of the key issues is attorney's fees, right? The VPPA allows damages, that's $2,500 in all likelihood, punitive damages, which I think would be pretty uncommon in a case like this. But 3 is attorney's fees, and that could be substantial. If you have a reputable firm litigating on behalf of a class, that attorney's fees claim could be significant.
And what kind of advice would you give companies who might fit under the VPPA?
The Salazar case highlights the fact that there was a large increase in data privacy litigation, not just under the VPPA, but under an assortment of state and federal laws. And it's really important to get your privacy disclosures right, get your terms of service correct, get your dispute resolution policies shaped up, and to begin to prepare your business for what could be one of these claims. You know, if you haven't talked to your in-house counsel or your outside counsel about what you can do to mitigate your risk, I think that, now is the time because this litigation is only accelerating.
It's great to have you on the show, Ira. Thanks so much. That's Ira Steinberg of Greenberg Glusker. President Joe Biden is on track to match or even surpass the number of federal judges appointed by former President Donald Trump. Biden has appointed 213 federal judges so far, compared to Trump's total of 231. But the next president is unlikely to be able to make an impact on the federal bench because the numbers just won't be there. Joining me is federal judiciary expert Carl Tobias, a professor at the University of Richmond School of Law. When Biden leaves office, he and Trump will have, in just 8 years, appointed about half of all the 890 life-tenured federal judges across the country. Is that an unusual amount for 8 years?
It is unusual. And the reason is both administrations and the majorities they've had in the Senate in those years have been of the same party and of the same mind, and that is to fill the bench with people they believe will be most effective. And they've been very effective in nominating and confirming people in that situation because the majority rules in the Senate. And so that's what we see. So it shouldn't be too surprising that there aren't a lot of opportunities for the next president, whoever it is, in terms of numbers.
And also there aren't opportunities because the judges taking senior status are shrinking as well. And is that because both these presidents appointed younger judges?
Yes, I think that's clear. I mean, I think the data show that. They intentionally did that. And that goes back, I think, at least to the time of George W. Bush and maybe even earlier, but it has become much more of a focus and emphasis. And sometimes the senators and the party opposing the president do point out that people are quite young and don't have a lot of experience. And so they criticize the nominees for that, but when the majority votes, they often then confirm those types of judges. And so that's what you have, I think. And I do think, to some extent, we're seeing a number of judges, especially in the appellate courts, only taking senior status or resigning when the person in the White House is of the same party, which used to be only a Supreme Court, or principally a Supreme Court type of tradition, and even then honored sometimes in the breach. But now it happens quite a bit. And what you saw, I think, for example, as Trump was coming in, was many Republicans assuming senior status. And then when Biden was elected, you saw a number of Democratic appointees then assuming senior status.
There are 67 vacancies currently on the federal bench or expected to open up. How many of those could Biden possibly fill before he leaves office?
Well, I think on the floor right now are 28. So that would only leave 40 or so vacancies working from the present figures, which is very low, especially at the appellate level. I think right now there's 6 vacancies, and 4 of them, and maybe 5 or even 6, could be confirmed. And that would leave virtually no vacancies in the appellate system. And that's where both parties concentrate, because appellate judges make more policy. They are the Supreme Courts in 99% of cases in the states within the circuit where they sit. And so everyone is focused on that. And I think at one point Trump actually had filled every single appellate vacancy, and that hadn't happened since 1984 when Reagan was president. So they focus like a laser on that. But so has Biden. And so he may end up with 48, 49, 50 appointees at the appellate level, which is very close to the 54 Trump was able to confirm.
So according to the American Constitution Society, which looked into how many judges might be taking senior status over the next 4 years, it came out to be 116 appointed by Republican presidents and 117 by Democratic presidents, which seemed awfully close to me, since I thought that Democratic presidents were behind Republican presidents on appointees.
Well, I think it has evened out during Biden's time. If you think back, Bush had 8 years, Obama had 8 years, Trump had 4, Biden had 4. So I'm not terribly surprised that that's where we are. But I think it's fair to say Democrats have learned from Republicans how to be more ruthless about nominations and confirmation. It depends on your perspective, but to some extent that's to be expected. I mean, I think that's the norm now. And so the majority rules in the Senate, and as long as the White House is amenable and the president is effective, that's what I think you're going to see going forward.
And I've been talking about judges for so long, but yet I didn't know this fact that it was President Jimmy Carter who has the record for the most judicial appointments in a single term, 262. And that was at a time when we didn't know it was as important as it is now.
I think that's correct. And there were fewer judges then because there were a couple of judgeship bills after that. But what's most telling is they passed the 1978 Judgeships Act, which created, I think, 35 appellate judgeships and 60 or 70, or maybe even more, district ones. And so he had an enormous opportunity there, and he seized it. That explains it, even though there were other criticisms of his presidency and he wasn't reelected. But he also, as you may remember, was instrumental in beginning the diversification of the courts in terms of ethnicity, gender, and experience, and appointed many people of color. All the Democratic presidents since then have made diversity important, and some of the Republicans have as well.
We have to factor in the fact that if the president, the next president, has a Senate that the opposing party has a majority in, is it going to be tougher to get judges appointed?
The answer is yes. Of
I
course.
knew that answer, but I thought I would give you a softball there.
Yeah, right. And the real telling point is 2015-16, after the Republicans in 2014 captured the majority, because Mitch McConnell, as majority leader, only allowed 2 of President Obama's nominees at the appellate level to be confirmed in the last 2 years, and not very many district nominees. That's what led to Trump being able to appoint 54, because there were so many vacancies held over by McConnell. And, of course, the classic example everybody remembers is what he did with Merrick Garland and Justice Scalia's vacancy. And that's what led, I think, in part to what we see in terms of the majority on the Supreme Court now.
Mike Davis, a Trump ally and founder of the conservative, judiciary-focused advocacy group Article 3 Project. He said the next president will finish the transformation of the judiciary one way or the other. Do you think he's right about that?
Well, to some extent, but remember, it's the appellate judges who really make the policy, and there are just not going to be many vacancies there. So some of what he is saying is hyperbolic, but there is a lot at stake. I just don't think the opportunity is there in a way that it has been historically because of the small numbers. And as we've talked about, the unlikelihood of very many turnovers in the next 4 years. And then the whole question of who's going to have the majority, because it may be that switches this time or not, but it's going to be very close no matter what. And there's every chance that even if Democrats lose the majority in this election year, they will recapture it in 26. And so I just don't think that there's going to be much of an opportunity to do what Davis is talking about. But I've seen what he has said, and they even are critical of some of the 54 whom Trump appointed as being, not sufficiently loyal, if you will, to the former president.
There's this theory that some federal judges sort of try out for the Supreme Court by writing opinions that they think will get them noticed. Have you seen that happening lately?
It's just hard to say, though I think it's fair to say, if you look at the 54 appellate judges, there are a number of them who seem to be trying out, and a lot of people have said that, for the Supreme Court. And it's a hierarchical institution, but there are not very many seats on the U.S. Supreme Court. So we'll see. But especially in the Fifth Circuit, for example, Trump has a number of appointees, and 11th Circuit, and they are people who have made their mark with, in some ways on certain cases. And even the Supreme Court has found the Fifth Circuit to be too extreme for its taste on certain issues, like the abortion pill and some other cases.
Yes, the Fifth Circuit often tends to push the legal envelope, so to speak. Thanks so much, Carl. That's Professor Carl Tobias of the University of Richmond Law School. Coming up next on the Bloomberg Law Show, a landmark doctrine of the NLRB is at stake in a Ninth Circuit case. I'm June Grasso, and you're listening to Bloomberg. A decision by the Ninth Circuit Appellate Court could have major implications on a game-changing NLRB decision on union organizing designed to clean up representation elections and provide a path to unionization without a formal vote. Joining me is Bloomberg Law senior legal reporter Robert Iafolla. Explain what the CEMEX doctrine is.
So this is mainly about the National Labor Relations Board's efforts to prevent employers from committing unfair labor practices before an election. Basically, the board looked at how things work, and because the remedy for violations before an election, if the union loses, the remedy is normally a rerun election, and employers tend to do better in rerun elections. The board looked and said, this is not enough of a disincentive, so we're going to rework how this all works. And they've set up a system now where if a union comes to an employer and says, look, we have a majority support, the majority of the workers here want to unionize, the employer has two choices. They can either accept that and recognize the union and start bargaining, or they can file their own petition for an election. If they go the election route, if they commit any labor law violations leading up to the election, then the board will issue what's now known as a CEMEX bargaining order. just basically saying you have to recognize and bargain with this union. And that's sort of how the doctrine works.
Well, what's the issue in the case? What is CEMEX saying?
So there was an oral argument at the Ninth Circuit about the CEMEX doctrine. The company CEMEX, which the case is named after, the doctrine is named after, is challenging the NLRB's basically legal authority to issue this rule, to create this this framework, this CEMEX doctrine. Basically, there was a Supreme Court decision from the late 60s called NLRB versus Gissel that set up the format for when the board would issue these sort of bargaining orders. Under Gissel, they would only issue these bargaining orders when there was severe and pervasive labor law violations such that there was no chance of holding a fair election. Just the law breaking was so intense that it destroyed that opportunity. And the company is saying that's the rule. The NLRB can't go in and change how they issue bargaining orders, in this new CEMEX doctrine. And that was the argument they presented at the circuit court yesterday.
Did the judges talk about the precedential value of Gissel?
Yeah, there was some debate over whether what the Supreme Court said in its previous Gissel ruling, whether what they were saying was this is a permissible way for the board to issue bargaining orders, or this is the only way that the board can issue the bargaining orders. The Democratic-appointed judges in the judicial panel that was hearing the case, they seemed to signal that they felt that Gissel was about what the board could do, not what the board must do, which suggests that at least at this stage, the NLRB may prevail.
What's the NLRB's argument at the Ninth Circuit?
Yeah, the board's argument at the Ninth Circuit is this is within their authority. And this is basically how the NLRB sets labor law policy for the country. They decide individual cases, and from those cases, they create general frameworks that sort of govern different areas of labor management relations. So they're saying, hey, we've had different standards through our history about what it takes to issue a bargaining order. There was a time before Gissel, there was what's known as the Joy Silk Doctrine, in which if a union came to an employer and said, we have majority support, unless that employer had a good faith reason to doubt that majority support, they were required to bargain. So it was a much more union-friendly standard, and that was allowed, in the 50s and 60s before Gissel happened. So the NLRB is saying, look, we've changed our standards before, and this is what we've changed it to now. This is what we think the best way to do it is, and we have that power.
So you write that the CEMEX lawyer raised Loper Bright, which was the decision by the Supreme Court at the end of last term that ended Chevron deference, or judicial deference to agencies' interpretations where the laws are ambiguous. What happened when that was raised?
So one of the Democratic-appointed judges spoke about part of the Loper Bright decision in which there are times when Congress has basically handed down some power to the agencies to kind of fill in the blanks and do this sort of doctrine setting, for lack of a better term. And the judge pointed out that, some of the cases that the court in Loper Bright referred to was, cases about the National Labor Relations Act, which is what empowers the NLRB. So I think she was basically saying Loper Bright doesn't affect anything in this case.
Because if you look at the Supreme Court decisions in recent years on unions, it's almost always against the union. So I wonder if this came up to the Supreme Court. I don't know if it will, but whether they would sort of not endorse it, the CEMEX doctrine.
Yeah, it's certainly a pretty high degree of likelihood that different employers will challenge, when they're hit with the CEMEX doctrine, they'll challenge that in court. Just yesterday, a NLRB judge issued a CEMEX order against Starbucks. So you can imagine that there will be what's known as a circuit split, where two different circuit courts disagree on an issue, and that's when the Supreme Court is supposed to come in and they're supposed to resolve that circuit split. So you could definitely see a situation in which the court was called upon to settle this issue. And as you point out, given the leanings of the current Supreme Court majority, you could imagine that the board might have an uphill battle.
How big a blow would it be to union organizing if there's a decision rejecting the CEMEX doctrine?
It's kind of hard to answer that with a lot of specificity, but we have seen the board just released some statistics recently about an increase in the amount of election petitions that are being filed, and I was speaking to some labor law experts recently about that, and an argument was made that, hey, that shows that the CEMEX doctrine is working. That shows that unions and workers see that CEMEX is providing sort of a stick to hold employers accountable so they won't violate the law right before an election to intimidate workers not to vote for unions. And we have seen an upsurge in unionization over the past few years. There's a lot of different reasons for that. It's not just the CEMEX doctrine. But it seems reasonable to say that that's part of it. So if the board was to lose the CEMEX doctrine, that would be not so great for unions.
Does CEMEX actually contradict GISL? Because it sets a whole different way of handling things, right?
Yeah, I don't know that it contradicts GISL, but it does represent a different framework. And as I mentioned before, the board has argued, look, we've had different frameworks before, some more permissive, some more union-friendly than CEMEX. GISL was more employer-friendly than CEMEX, but it may come down to a technical question about what exactly did the Supreme Court say in that, I think it was 1969, was the GISL ruling. Did they create a situation where they said this is the only way you can do it, or did they rule that, yes, this is a permissible way to do it, but implicitly they're saying, board, you could set up another way.
So how do you think this Ninth Circuit panel is going to come out?
Appellate courts, the politicization, seems to be there where you can't decide the outcome just based on the composition of the panel. But here we had two Biden appointees and one George W. Bush appointee. And watching the arguments, it did seem that the two Biden appointees were a lot more supportive of the board's position, and the George W. Bush appointee was more skeptical of the board's position. So they seem to signal that they would end up approving the CEMEX doctrine, but we'll have to see.
An important labor case, no matter which way you look at it. Thanks so much, Robert. That's Robert Iafolla, senior legal reporter for Bloomberg Law. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.